Aircraft Owner Trusts. Hello, this is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Let's begin with one of the most important issues in private aviation for international clients: how a non US person can lawfully access US registration. At the statute level, the starting point is 49 USC section 44102. At the regulatory level, the key FAA provision is 14 CFR section 47.7. The baseline rule is straightforward. An aircraft may be registered in the United States only if it is not registered in another country and it is owned by a qualifying registrant. For many non-US beneficial owners, that eligibility does not exist directly. This is why the Aircraft Owner Trust remains such an important tool. An owner trust separates legal title from beneficial ownership. The U.S. citizen trustee holds legal title to the aircraft. The non-U.S. party holds the economic and practical interest through the trust structure and related agreements. This sounds simple. Maybe it doesn't. It's not simple. The FAA has made clear for years that an owner trust is not supposed to be a paper disguise. It is supposed to be a real legal relationship that satisfies the regulations in substance, not just merely in form. Under Section 47.7, each trustee must be a U.S. citizen or resident alien. The registration application must be accompanied by every document legally affecting the trust relationship. And if any beneficiary or secured party under the trust is not a U.S. citizen or resident alien, each trustee must prove or provide an affidavit stating that the trustee is not aware of any reason, situation, or relationship that would allow non-U.S. persons to hold more than 25% of the aggregated power to influence or limit the trust's authority. That 25% concept matters. It is one of the places where practitioners get into trouble when they focus only on beneficial ownership and do not focus enough on control rights. The trust instrument must also address removal and direction rights. If non-U.S. persons have the power to directly or indirectly remove a trustee, they may not collectively hold more than 25% of the aggregate power. In other words, foreign economic ownership can be broad, foreign control over the trustee cannot. The FAA's 2013 policy clarification sharpened this analysis. The agency said it wants to see not only the trust instrument, but also operating agreements and similar side agreements that affect the trust relationship. Silence is not enough. If no such side agreement exists, the applicant must prove adequate assurance of that fact. The FAA's message was unmistakable. Show us the real deal structure. Don't just show us the front page. Practically, this means the trustee must have rights that are real enough to satisfy the registry and credible enough to survive scrutiny. That can also include information rights, notice rights, rights tied to downstream possession of transfers, and rights to act when necessary to protect compliance. Those rights may rarely be exercised, but they cannot be fictional. Here's a point to remember. The FAA does not want a cardboard trustee. It wants a trustee with legal muscle, even if that muscle is used sparingly. There's another operational issue that deserves more attention than it usually gets: trustee quality. Choosing the cheapest trust company can become the most expensive decision in the transaction. The trustee is the record owner. If that trustee becomes insolvent, unresponsive, administratively impaired, or simply difficult, you may have a serious title, registration, and closing problem at exactly the wrong moment. A sale can be delayed, a refinancing can be delayed, an enforcement event can become more complicated. Even a routine amendment can turn into a negotiation. From a transaction planning perspective, the owner trust should therefore be evaluated on at least 4 levels: regulatory compliance, trustee independence, document integration, and institutional reliability of the trustee itself. Also, remember what FAA registration does not do. Under 14 CFR Section 47.5, registration is not evidence of ownership in any proceeding where ownership is disputed. So the trust and title documents still need to be drafted with the same discipline you would bring to any other high-value asset transaction. In short, owner trusts are lawful, common, and often the best solution for non-U.S. persons seeking U.S. registration. But the structure only works when the documents are aligned. The trustee is genuinely qualified and independent, and the parties understand the FAA compliance is ongoing, as an ongoing condition, not a one-time filing event. I want you to take this away. An owner trust can open the U.S. registry, but only a well-built owner trust keeps that door open. Voting trusts. Hello again, this is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Now let's turn to voting trusts. This is a different tool used for a different problem. An owner trust addresses who holds title to the aircraft. A voting trust addresses whether an entity can qualify as a U.S. citizen for registration purposes. The controlling definition is in 49 U.S.C. Section 40102A15. For a corporation or association to qualify as a U.S. citizen, it must be organized under U.S. law. Its president and at least 2/3 of its board and other managing officers must be U.S. citizens. It must be under the actual control of U.S. citizens, and at least 75% of the voting interest must be owned or controlled by U.S. citizens. When those citizenship percentages are strained by foreign investment, a voting trust may be considered. But this is not a casual fix. It's one of the most scrutinized structures in the registration rules. Here, the key FAA regulation is 14 CFR Section 47.8. If a voting trust is being used to qualify the corporation, the applicant must submit a true copy of the fully executed voting trust agreement. That agreement must identify each voting interest and must bind the voting trustee, the applicant corporation, the foreign stockholders, and other parties to the transaction. The FAA also requires an affidavit from each voting trustee. Each trustee must represent that he or she is a U.S. citizen with statutory definition. It is not a past, present, or prospective director, officer, employee, attorney, or agent of another party to the trust agreement, is not a present or prospective beneficiary, creditor, debtor, supplier, or contractor of another party, and is not aware of any relationship that could influence the exercise of totally independent judgment. That is not window dressing. It is the FAA telling the market exactly what it fears: hidden influence dressed up as formal compliance. The phrase I would emphasize here is actual control, because actual control is where voting trust structures either stand or fall. The FAA will look past elegant drafting if the real world arrangement allows foreign parties to call the shots. Who selected the trustee? Who can replace the trustee? Are there side letters? Are there veto rights? Are there financing covenants that effectively dictate governance outcomes? Does someone outside the voting trust still have the practical ability to force decisions? Those questions matter more than the rhetoric in the recitals of the documents. Another important point, the voting trust agreement must provide for succession of a voting trustee in the event of death, disability, resignation, loss of citizenship, or another replacement event. And the replacement trustee must immediately submit the required affidavit. A broken succession mechanism can become a broken citizenship analysis. Also, a voting trust must not empower a trustee to act by proxy. The FAA wants the trustee exercising independent judgment directly. From a corporate and transaction perspective, voting trusts can create second-order issues that should not be underestimated. They can affect shareholder expectations, government or governance dynamics, lender diligence, negotiated control protections, and sometimes tax planning. A structure that solves an FAA citizenship issue on paper may create a broad control or board control problem, a lender consent problem, or a dispute resolution problem somewhere else. So, the right question is not simply, can we build a voting trust? The right question is, can we build one that is compliant, financeable, governable, and durable? Periodic review is essential. If ownership shifts, if board composition changes, if side agreements are amended, or if a financing package introduces new control rights, citizenship compliance can erode without any obvious warning light on the panel. I'd like you to remember this. Take this away. With voting trusts, the FAA is not counting shares only. It is tracing control. When properly structured, voting trusts can reconcile foreign capital with U.S. registration requirements. When poorly structured, they invite scrutiny, delay, and potential loss of registration eligibility. The bottom line is simple. A voting trust is not a cosmetic solution. It is a precision instrument. And precision is exactly how it must be drafted, implemented, and maintained. Based and primarily used registration. Finally, let's discuss the registration pathway that is often mentioned but frequently oversimplified. The based and primarily used rule. The pathway is grounded in 49 U.S.C. section 44102 and implemented in 14 CFR section 47.9. And the first correction to make is an important one. This is not a broad registration option for any non-U.S. person. It applies to a corporation that is not a U.S. citizen, but is organized and doing business under the laws of the United States or a state, with an aircraft that is based and primarily used in the United States. This limitation matters. If the ownership profile does not fit the statute, this pathway does not fit the transaction. Under Section 47.9, the corporation must submit a certified copy of its certificate of incorporation, a certification that is lawfully qualified to do business in one or more states, a certification that the aircraft was based and primarily used in the United States, and the location where the required flight records will be maintained. There is also a 60% test. It's more technical than many operators realize. For FAA registration purposes, the aircraft is based and primarily used in the United States if the flight hours accumulated within the United States account for at least 60% of the total flight hours during the remainder of the registration month and following 6 calendar months, and during each 6 calendar month period after that. So there's reporting requirements every 6 months. And the rule does not count every U.S. connected flight the same way. Under Section 47.9c, only flight hours accumulated during nonstop flights between 2 points in the United States count as flight hours accumulated within the United States, except for emergency or refueling stops. That is a much narrower definition than many people assume or realize. In addition, the corporation must maintain those records and make them available for FAA inspection upon request. And the records must be kept for 3 calendar years after the year in which the flight hours were accumulated. That is why I often advise clients that based and primarily used registration is not a filing strategy. It is actually an operating discipline. If the aircraft's mission shifts towards international activity, the structure can quietly drift out of compliance. And under 14 CFR Section 47.41, when the applicable period described in Section 47.9b ends and the aircraft was not based and primarily used in the United States during that period, the certificate becomes ineffective. That is not a technical nuance. That is a real registration event. Operationally, this can affect much more than the registry file. It can raise issues for lenders, insurance, counterparties, and any transaction that assumes valid and continuous registration status. This is also a broader regulatory backdrop. U.S. registration does not itself solve economic authority issues, charter issues, or cabotage issues. Operators still need to analyze how the aircraft is being used, by whom, and for what kind of compensation or business purpose under the applicable FAA and DOT framework. So, yes, based and primarily used, that pathway can be effective, but it works best for aircraft with a genuinely stable U.S.-centric operating profile. Disciplined flight hour tracking and management teams that understand the rule is measured continuously and not casually. I hope this point sticks. This pathway for based and primarily used registration is not self-executing. Every flight hour is a vote. If the aircraft consistently flies the right profile, the structure holds. If the profile changes, the registration risk changes with it. In many international ownership scenarios, the ongoing operational rigidity is exactly why parties prefer owner trusts instead. The owner trust often provides more flexibility, while the based and primarily used pathway demands operational consistency. My closing thought is this. The right registration structure is not the one that works on signing day. It is the one that still works after financing, after the management agreement, after the itinerary changes, and after the FAA asks for the file. Thank you for your time and interest in this topic. This information is provided for informational purposes only, and it should not be construed as legal advice. Questions are absolutely welcome. Please direct them to admin@aviationlegalcounsel.com. We look forward to helping you navigate these questions and issues with precision.